Commission. We'll call the roll. Vice Chair Chu.
Here.
And Commissioner Rennie.
Here.
Commissioner Kopp.
Present.
And Commissioner Hayon resigned last week from the commission, so we have a vacancy that the mayor will be filling shortly, we hope. First, we'll take public comment on matters appearing or not appearing on the agenda.
Thank you, Chair, members of the Commission. Larry Bush, speaking for Friends of Ethics. We just want to acknowledge the work of Beverly Hayon, Commissioner. We appreciated her participation. I think she had almost a full 6 years because she had a part of an earlier term. And she was a stalwart member of the Commission.
For the record, I'm Charlie Marsteller, and I'd like to second that. I think any commissioner that has served at this time is responsible for helping to bring the commission light years ahead. And it's good to see a commission growing up, and I think Commissioner Hayon certainly participated in that process and encouraged others to follow, such as Commissioner Kopp, and also helped us secure the appointment of our new stellar staff. So I wanted to thank her for her service.
Commissioners, Ray Hartz, Director, San Francisco Open Government. So we were talking about the ongoing fraud being perpetrated on the citizens of San Francisco by the Office of the Mayor. From the findings of the Fair Political Practices Commission in Sacramento, Respondent Luis Herrera, while serving as city librarian for the San Francisco Public Library, failed to report gifts received from the Friends of the San Francisco Public Library on annual statements of economic interest for calendar years 2009, 2010, and 2011 in violation of Government Code Section 87300. And these were no small sums. They were $5,000 a year approximately that he was getting in gifts that he knew he was required by law to report. And in the first column, his original filings all said zero. And I will remind you that if you look at the bottom, it says, I certify under penalty of perjury under the laws of the state of California that the foregoing is true and correct. So for years, he was filling out these applications, and actually it was 10 years before this that he was doing it also, but they couldn't go any further back because of the statute of limitations. But we got him for 3 years. So a city department head appointed by the mayor perjured himself by lying year after year after year. Almost $15,000 over those 3 years, and I calculated another $50,000 to $55,000 the 10 years before we took him to the FPPC. We brought it to the Ethics Commission, and the former executive director refused to even look at it. Just said, go away, don't bother us. Which is why I previously at a meeting said here, what's the purpose of having statements of economic interest if someone finds a city department head who is responsible for an entire city department, including himself, to file these honestly, and he perjures himself year after year, and we bring it to the Ethics Commission, the Ethics Commission turns a blind eye. Did he do this knowingly and willfully? Yes, he did. He knew what he was doing was wrong, and the reason I will tell you that is I believe that is that the San Francisco Public Library Commission has never, ever discussed this. What they actually did is when this finding was released by the FPPC, they had an unlawful meeting where they met and discussed their support for Mr. Herrera and issued a press release based on that. And then after that was the bell was rung, I said, oh, we shouldn't have had that meeting. We'll withdraw the press release after it was already published in the newspaper.
Okay, seeing no further public comment on... Any other, on, on matters not appearing on the agenda? Oh, sorry. Thanks, Steve.
Just spiked up.
Sorry.
Some blank pages and some popular pages. Quick bike ride. My name is Mark Solomon. Commissioners live in the Mission District. And there are some issues I'd like to go ahead and bring to the attention of the Commission. I've been working to establish a legislative record on Prop J. I found out that the data provided on Planning's website is deficient in several key manners. There's no contact, sponsor, or cost information provided for some 80% of project records. The Planning Department disavows any responsibility for these omissions and directs me to the DBI, which is basically saying go into a bureaucratic minefield and fend for yourself. The fact is we've got 1,300 projects, and only 20% of them have actual contact information to figure out who the sponsor is. So we really can't connect campaign finance and approvals to figure out who's paying for what. I think the Commission should require that the department updates their records in this regard within 48 hours after receiving a filing so the public can know what the department's up to. Major developers may not be filing with the Ethics Commission on contributions they make to nonprofits who advocate for their projects. This needs the attention of ethics staff as well, and a reminder to all developers. This underscores the need for a full and complete posting of pipeline project sponsors as well, so folks can know where campaign contributions go to from developers to electeds and towards nonprofits to make projects more politically feasible. And also, as commissioners take on new outside duties and jobs, especially if there's a potential conflict of interest in or appearance, the ethics needs to act to quickly notify all commissioners of the need to recuse or resign. This should be shared with the city attorney as well. The Commission should ensure that the enumeration of incompatible activities for commissioners includes such conflicts. My work in Prop J research has, led me on some of this work, and we have Planning Commissioner Christine Johnson is currently employed by San Francisco Planning and Urban Renewal Association, SPUR, which is essentially a developer lobbyist shop, and she's sitting there approving projects as well. Her nonprofit is funded by developers, their consultants, attorneys, architects, etc., and she is sitting there approving their projects. That's a blatant conflict of interest. If it's not incompatible, it should be, and ethics needs to be sure that we get a handle on that. I just biked for 4 miles, so I'm a little bit hot. You guys have the text and can figure the rest of it out. Thank you.
Thank you.
Mr. Chairman, if I may comment, Mr. Solomon, I think on that last one, isn't that part of what you're going to propose tonight?
Yes, that would certainly come in. What Mr. Solomon has just outlined would certainly come under what we're about to propose on the restoration of Prop J. That's fine. Any further public comment on matters that are not on the agenda? All right, we'll move now then to agenda item 3, a discussion and possible action on the draft minutes for the Commission's February 27th, 2017 regular meeting. Do we have any comments or requests for corrections to the minutes?
I'm going to make a precedential motion, but I see Commissioner Rennie may thwart that, to approve the minutes as proposed.
I would second it with one amendment. If you look on page 4, item number 7, the second line, Michael Petrellis's name is misspelled. You left the I out, so that should be corrected. And other than that, I second
accept
your
the
amendment.
Any further observations on the minutes of our last meeting? Yes, fine. Have some public comment on.
Commissioners Ray Hartz, Director, San Francisco Open Government. I'd like to turn your attention to page 5 of these minutes under the agenda item 8, discussion of the Executive Director's Report. And if you notice there, it says the following written summary was provided by Speaker Dr. Derek Kerr, the content of which is neither generated by nor subject to approval or verification of accuracy by the Ethics Commission. That 150-word summary, Dr. Kerr is the only person I know that is taking advantage of the thing that I fought for 3 years to get, and that is the law in San Francisco is that if you make a statement, a public hearing, and you provide a summary of 150 words or less, that statement shall be placed in the minutes, in the body of the minutes, at the point where the discussion was held. And Dr. Kerr is the one person who has taken advantage of this. And I think anybody who reads the minutes of meetings, whether it be this Ethics Commission or any other body of this city, will find out that your First Amendment rights are violated on a regular and ongoing basis. They are censored, abridged, and any other permutation you can think of. And if you look at these minutes, basically what they say is there's a little brief statement like, Mr. Rayhart's got up and said something about something. And that's the summary of your 3-minute comments. So if you want what you have to say to make it in the official record, submit a 150-word summary of your comments, and they will be in the record. Dr. Kerr has done it, and I think if you read his comments, he was talking about the whistleblower program, and he did a very cogent thing when he put this in here, gave some very valuable information to the Ethics Commission. And Dr. Kerr should know, because he was the recipient of a $750,000 settlement from the city as a whistleblower. He knows what they do, and he knows that you can hide. The city will do everything they can to hide their wrongdoing and to protect their own.
Do we have any further public comment on the minutes of our last meeting? We have a motion by Commissioner Kopp that the minutes be approved. Is there a second to that motion?
I second it.
All right. All those in favor?
Aye.
Aye.
Those opposed? The minutes are unanimously approved. We'll go now to agenda item number 4, the presentation and discussion of staff report on public financing in the 2016 city elections with an attachment to the March 22nd, 2017 staff report and further attachments.
Thank you, Chair Keane. I wanted to thank our Assistant Deputy Director, Shaista Sheikh, for leading the effort on producing our report this year. She's unable to be with us this evening, so I'm stepping in just to provide you with a brief overview and to try and answer any questions you might have. I would also note, just as a clarification, on the agenda, we do refer to a March 22nd staff report. It is referring to the report for item number 4, which happens to be dated March 23rd. So just to, they are the one and the same, and we will continue to proof and correct our errors, hopefully before they get to you. But thank you for your understanding on that front. First of all, this is a report that the Commission is required to issue every year following an election to submit to the Mayor and Board of Supervisors on the public financing in the prior election. This is under Section 1.156 of our Campaign and Governmental Conduct Code. The report that we have, again following last year's model, provides the required information that is specified in that section, and importantly provides some historical overview of our public financing program in city elections from 2002 to 2016. This is based on reports that candidates filed through December 31st of last year. The most important thing, I think, to think about this report is that, as with any public policy program, it is important to periodically assess what steps are needed to promote the effectiveness of that program. So we have a legal requirement to produce a report and send it on to the board, but importantly, from the staff's perspective and hopefully for our conversations going forward, this is a document that we hope will be used to broadly engage candidates, contributors, others who've been active in city elections, and the public in assessing issues related to our campaign financing framework, and in particular our public financing program, to make sure that it is as strong as possible, that it encourages candidate participation, and that overall the program is effective in achieving the goals that the voters set out for it. You'll remember that the program was first established back in 2000. It's been through a variety and a number of changes over the years, but the goals of the program remain the same. It's a program that is designed to offer candidates the opportunity to rely more on a neutral source of funding for their campaigns, to encourage limited spending as much as possible so that candidates can spend less time fundraising and more time communicating with constituents about critical issues in the communities. that they're serving, and also to leverage the importance of relatively small individual contributions in city campaigns. So that these programs are designed to help encourage new and diverse voices, both among those who are running for office and those who elected officials are represented or elected to represent. The information that we provide in the report, we hope, will also provide an empirical basis for the conversation going forward about the campaign financing system in the city and county of San Francisco. And as we look to the planned assessment of our campaign financing programs and rules launched later this spring, there are a number of questions that we end the report with. Are there ways, for example, that the current mechanics of this program might need to be improved so that those mechanics are not acting as unintended impediments for candidate participation? Are there ways the public financing program can be strengthened to better balance its benefits for non-incumbent candidates? And do current timeframes for the distribution of funds work for candidates and to help support the goals? Are there different formulas that we might examine in terms of grants and rates of matching funds to determine whether there might be ways to, again, further incentivize candidates to want to participate in the system? And most importantly, are there mechanics that we should be examining that could be improved to better engage voters in city campaigns? So this report does not intend to answer those questions. It does intend to provide empirical data from the last election and from prior elections as a basis to start and support that conversation with the most recent experience of our public financing program. So with that brief overview, I'm happy to answer any questions or hear public comment and respond to any questions that might come up.
Commissioners? Commissioner Cobb.
I've got a couple of questions about how the money is set up. There's a legal limit of $7 million per fiscal year, right?
It's a maximum fund of $7 million at any one time.
Yeah.
So yes.
Well, any one time fiscal year.
Yeah, it's
Okay.
It can be no more than $7 million.
And this year, apparently in the budget, there was an estimate, because that's what a budget usually is, of about $650,000, right?
For the current fiscal year that we're in? Yeah. I don't have that number in front of me, but that sounds in the ballpark.
Well, I don't know if I got it here or I got it from Ms. Bloom. And actually, there was distributed over twice that, $1.3 million, $1.4 million. It's in here somewhere. It's a very good report. It's an interesting report, too, especially the history. And I would assume, and please verify, that the estimate is based upon how many qualifying elections there will be, how many Board of Supervisors elections, whether it's mayor, anybody else who qualifies. What do you do now for 2017-18 fiscal year in putting in the estimated amount?
In any year, as you point out, there's a maximum. A budget is a projection, as you point out, of a potential draw that might result from a campaign and from the projection of the number of candidates who might participate. So we did have an allocation based on a required formula of $2.75 per resident that needs to be put into the fund if the fund is not already at its maximum. What we've looked at for this year is, because the fund is at its maximum and we don't anticipate draws that are going to pull it down beyond that, that there's not going to be a required allocation into the fund.
How much is in the fund now, approximately?
I don't have that number off the top of my head. I'm sorry, but I can get that for you.
All right, so we don't have to run a deficit, to use an inexact word. Mm-hmm. Is that correct?
As I understand it, yes. We
Yeah.
have funds that are allocated for the purpose.
Okay, thank you.
Any further comment by members of the commission?
Chair Keane?
Oh, yes.
So,
Commissioner Chu.
Executive Director Pelham, these questions that you raised at the bottom of page 9 are, very thought-provoking. Do you plan to address them when you are fully up to staff? For example, perhaps when the policy analyst is on board?
Yes, this is, as we'll see in the Executive Director's report later, the Commission has for some time had on its annual policy plan reviewing the campaign finance reform ordinance following the issuance of this report. So we expect that these questions, among others, will be folded into conversations that begin this spring once we have our policy team in place and starting to get steeped in our city campaign finance laws.
I look forward to that.
I have one other
Yes,
question.
Commissioner Cobb.
In doing business with this program, with the public, do you get suggestions from applicants for public financing?
Yes, we do during,
Okay, and do
during the
you-
course of the election.
Retain those?
Yes.
Okay. And do you consider them in terms of the elements and items you mentioned on page 9 of the report?
Yes, and I would add that one of the things that I think is critical that we do going forward is not just the information we get during the course of the election, but once there's time to step back and take stock of the election, to really sit down, have interested persons meetings, do proactive outreach, really sit down and understand how people are working in the system, what's helpful, what could be improved. So we're planning to reach out in a much more direct way as well.
Good.
Any public comment on this item?
Hello again, I'm Charlie Marsteller, and I'm representing FOE at this time. I did want to thank the staff for this excellent report and this extremely interesting historical perspective. I think this is the first time we've seen anything quite like it. And normally we see a snapshot year to year, but not a comprehensive type of report. And I'm glad this is on the agenda because this started in 2000 on the ballot. And the first year of operation was 2002, I believe, and you indicated that we probably now have enough data where we can take a good look back and see where all of this has led. I would say that your questions are extremely good, and then we have questions of our own, both in items that have been subsequently repealed by this body for various reasons in historical perspective, and by court decisions that have occurred subsequently. There's one in particular that I would want to draw your attention to, and that's the one I sent you the former staff memo on, dated July 7th, 2011. And that was the Arizona decision, Arizona Free Enterprise Club, Freedom Club PAC versus Bennett. And that was basically a decision that this body unfortunately blew by proposing to the board to repeal the law on a 4-to-1 vote. Commissioner Ward and I argued very ineffectively, unfortunately, that is not proper. We should have taken the whole issue to public hearing as Maine Ethics Commission did. Maine's Ethics Commission did find 2 remedies or workarounds from the Supreme Court decision, and that is the U.S. Supreme Court, that on a 5-to-4, I should mention. And one of them was from the Brennan Center for Justice in New York, and they proposed those to the legislature, but unfortunately the politics in the legislature had changed by the time that recommendation went, and there was no process or progress in Maine. But that doesn't mean that we can't revisit it and bring it back here at this time. You have the memo, so that'll give you a heads up. There are some other provisions that FOE is looking at that have been repealed and that we intend to raise with you in these interested persons meetings, which should be quite lively. And I do recommend that commissioners attend if they can without violating the Brown Act. It would be a good didactic on the subject of public financing and some of the new purposes that I have discovered as a result of my years of study of this measure. I'd like to get into that, but my time is up.
Thank you.
Commissioners, Larry Bush from Friends of Ethics. Just adding on to what Charlie has said, which Friends of Ethics completely supports. Among the issues that have been dropped along the way, but what Charlie is suggesting be re-examined is the aggregate contribution limits, which we used to have, but which were wiped out when the Commission acted somewhat precipitously earlier. Also, there was a requirement in the past.
Microphone, Mr.
I have to make love to it, I guess. So, in addition to that, there was a requirement in the past that those candidates who accepted spending limits were identified in the voter handbook as having accepted spending limits. And at some point, Mr. St. Croix decided that was too much work for the Ethics Commission, so they repealed that requirement. We'd like to see that requirement reinstated. The third thing is the point that Executive Director Pelham made, which was that one of the points of purposes of public financing is to encourage greater participation. And right now, the law only requires one debate to take place between candidates if one of the candidates is taking public financing. Given the way the world has changed since this was passed in the year 2000, we would recommend consideration of something like a required email to every voter in the jurisdiction where the candidate is running. Because in the end, what we found from the California Voter Foundation and others is that if people are asked to vote, they are more likely to vote. And secondly, if you don't do that, what you've essentially done is provided public financing for people to cherry pick only those potential voters who are inclined to support them anyway. So it becomes a get out the vote thing for the candidate rather than a way of increasing voter participation. So when you have your interested persons meeting, we'd like those issues included. Thank you.
Thank you.
Yes, Commissioners, Mark Solomon again. I would like to look back to 2011 to get some lessons from that public financing round. There are those who said that Chow En-lai was asked in the 1970s what he thought the effects were of the French Revolution. He said it's too soon to tell, so we couldn't know this at the time. They said it was misquoted. He was talking about Paris 68, but we don't know. So we look at 2011, and we saw that there was many candidates running for for a seat. It was the year that Ed Lee was running for his first go. And former Supervisor Dufty had termed out in 2010. He maxed out, raised the most public financing for the mayoral race, got to $1.5 million, and essentially ran not against Ed Lee, not for anything, and didn't really turn out well in the polls. He ended up getting a job for 4 years as homeless czar, which he used to go ahead and keep his political coals warm until he made his jump to the dartboard this year. So I think we should probably look at some controls on possible city employment with another candidate. If you run public financing and really, if you run public financing, you should have a 2-year window where they can't hire you for any sort of executive position, because that was a good, $600,000 of public money to Supervisor Dufty to not really deal with homelessness. And he used it for his own political trampoline to keep his political life alive. And I think that's an unintended consequence that the Commission could close the door on. Thank you.
Thank you. Any further public comment on this item? All right, there's no action that's necessary on this item, so we'll now move to agenda item 5, discussion and possible action on proposed revised method for selection of campaign audits for the 2016 audit cycle. Director Pelham.
Yes, thank you, Chair. This is a report that is coming to you for your information and discussion and any policy action that you might wish to take. It does not require the Commission to take action, and this is a bit of a revision from prior practice, but it is not a change or a deviation from the law. As you know, after every election, the Ethics Commission has the duty and responsibility to conduct audits of campaigns and of those who ran for city office. The methodology, the requirement under the law is that we audit by either random selection or targeted audits, committees. We don't have specific requirements of who must be audited. We have had a practice in the past of selecting by a sort of stratified sample committees to be audited that factors in both the type of committee, candidate committees, ballot measure committees, and general purpose committees, as well as the relative spending and campaign activity that those committees demonstrated. We have been in a period of change and transformation at the Commission, at the staff level in the last year and a half, as you know. We have been attempting to revise a number of our processes and had hoped to bring a very in-depth report of our audit program to you in conjunction with this report to highlight ways in which we are going to change our auditing program itself internally. We have not been able to do that. We are still struggling to complete audits from cycles that we have already selected. We have remaining audits for lobbying that have not yet been started, as the report indicates. We have audits from last year's campaign selection that we need to continue to complete. So that's one factor that we looked at in this analysis and in the recommendation we're bringing forward tonight to take a different methodology. And it's also in line with several guiding principles that we think are helpful to articulate about why and how we want to approach audits going forward. First, we believe that it would be in keeping with the Commission's past practice of doing random selection of audits. That goal is to make sure that audits are not in any way selected based on the candidate or the issue that is supported or opposed by those campaign activities. That is not a relevant factor in selecting audits. And at the same time, in previous years, audits have not captured a lot of some of the money that has been used in affecting city campaigns. And so one of the goals is to make sure that we believe that we should be trying to audit as much of where the public interest is the greatest. We believe that's often the case where there is the largest money spent to influence voters. So that is one of the factors that we also looked at. So to making sure that we want to make sure that the audit selection continues to be objective and transparent, having conversations before the Commission, to focus most significantly on where the public interest is greatest, where there is a lot of money being spent, and to take a bit more advantage of what is the language currently used as targeted audits. And by that, we don't mean targeted to a particular candidate or issue, but we mean targeted to a particular type of criteria. So for this audit cycle, the Commission staff is recommending that we move forward on audits, looking at those factors, and where the money was spent most greatly. We're proposing that we take the top 5 in each category of committee for audit. Now, we also think that the thoroughness and impact of Commission audits from audit cycle to audit cycle would benefit by having objective criteria that might vary from audit cycle to audit cycle. It may be that there are particular issues around independent expenditures or ballot measure committees or other topics that might suggest we develop objective criteria going into the audit cycle, but again, that is not targeted at a particular candidate or a particular issue. So having some flexibility from year to year to focus where the public interest might be the greatest is something that we think would be beneficial. So when we looked at the 2016 election cycle for November's election, we had 165 campaign committees that reported roughly $70 million in spending, $70 million. It is the fact that we do not have the resources to audit 100% of all these committees. But we took a look at the committee types and the level of spending that they had, And as you see on attachment 1, when you take a 5-year look back, the proposal that we have this year that we're planning to move forward with, depending on the Commission's comments and feedback tonight, is that we would be auditing 114 there are 114 committees in the audit pool. That we would be auditing in total 27 committees, which reflects 24% of the committees in that pool, but 80% of the money in that pool. That's significant because the number of committees audited would be roughly on par with recent years, but it would increase the amount of money that's being audited in the election from a recent high in 2013 of 64% of the money to 80% of the money that was reported this year. So there's always a bit of a balancing act to try and make sure we're grabbing the most significant campaigns. We looked at this without any regard to which committees fell into the top 5 or below the top 5. That information is presented in attachment 2, but it was not factored into our analysis. We looked at the money and the percentage of committees. The idea is that under our authority, as the charter, as the city law provides currently, we can do targeted audits, but what we mean by targeted audits, again, is not individuals or types of or specific committees, but targeting a particular type of criteria in any election year. So we are not recommending that the Commission pull from a random selection process going forward for this election. We are planning to have actually initiated and will continue to work the mandatory audits of our publicly financed candidates, which is required under the law. Those audits are going to be conducted through the City Controller's Office. We're very pleased and grateful that they're able to provide that service to us. Under the charter, if there is a request, under the law, if there is a request from me for them to provide those services, they do provide them. So their staff, their contract staff, will be working the publicly financed candidate audits that are mandatory. Our staff will continue to complete the audits that have yet to be completed from the prior election cycle, but will then also be responsible for the 12 other audits of other than publicly financed candidates. So we realize this is going to take, it's a priority for us to look at our audits and to really get through them as thoroughly as we can and as quickly as we can. Our staffing has been impacted over the last year and with public finance program and just various staff issues. So we're looking forward to bringing these forward and with a goal of completing them within the next 12 months. And then again, taking a step back from that to really look at a much more comprehensive review of our auditing program to make sure that it is as strong and thorough as possible in the impact that we bring to our auditing function. So that's a bit of an overview of where we are. Again, I'm happy to answer any questions, provide any additional information that I can.
Commissioner Kopp.
What you have described is a process which is not statutory, but it is discretionary with the Commission and through the Commission, the staff, which does the actual work. And do you recommend that it continue in that respect rather than be reduced to a regulation, much less an ordinance?
Yes. Okay. Yes, I would.
Thank you.
Commissioner Chu.
Director Pelham, I have a question for you as well as a comment. In the beginning of your report, you noted that on page 3 that 16 to 24% of committees in the audit pool have been audited, and overall anywhere from 8 to 64% of the expenditures were audited. Is there a benchmark or a best practice of a measure that other commissions have either hit or aspire to?
I can speak to my experience when I was with the Los Angeles Ethics Commission. Their law requires all committees to be audited if they raise or spend over $100,000. So there is there's a floor, and then everybody above that is required to be audited.
May I interrupt for a second? Yeah.
Yes, Commissioner Kopp.
Is that by rule, by ordinance, or
yes.
It's which rule?
Oh, by statute, by ordinance.
Statute.
Yes.
Okay.
And I think that's can be a very effective way to go about providing accountability for campaigns. I think we are not yet there because we need to take a look at our auditing process. I believe they are thorough,
That
but I
leads
think
to the question, do you think that's the preferred method, or is it preferred to grant administrative discretion? I can see an argument both ways, I suppose, but I'm satisfied with administrative discretion because it provides uncertainty to the filers.
I think that's a factor. I think I'm a year away, an audit cycle away from having an assessment about whether I have a different view. Should we propose there be a required floor under the law? Possibly, but I don't believe I have enough information at this point to make that recommendation.
Thank you. And then my second is a comment. So in looking at the percent of funds that were audited, it is a low of 8 and a high of 64, but if you average it, it's only about, did the math, 32.4%, so it's less than a third. So I strongly support and would very much be in favor of focusing our efforts on targeting a higher percentage of the funds that are expended. So this 80% proposal for 2016, I think, is a very good start for 2016. For this year, to provide a little more information and insight, and then a year from now we can revisit this to see whether a floor is appropriate, and would like to hear your recommendations. But as I've discovered in my career, it's always the 80-20 rule. 20% of the problems will come from 80%. 80%. Yeah, 80% of the problems will come from 20% of the population. So I think that this is a good split.
I just want to say I read this with great interest, and I agree with some of the conclusions you've come to. And one of the criticisms that have been leveled at this commission is that all we've done is targeted the little guy and gotten after the small fish and ignored the big fish. And it seems to me what you're proposing here at least is an attempt to put our focus where if there is something going on or some reason to bring some action, it'll be focused on those committees or those candidates who are raising and spending the most money. So I applaud going that approach.
Any other questions by members of the commission, comments? If not, we'll take public comment.
Commissioners, Larry Bush for Friends of Ethics. We would suggest another category in addition to the ones that you have of various committees, and that would be a category of major donors. That while they are not a committee per se, it used to be that the Ethics Commission did track major donors, did do audits on major donors, and that did turn out to produce some very important information, including criminal convictions. But as a result of the result, the decision was made by the then executive director to no longer do audits of major donors, and so there have not been any done or any real tracking of them. So we would suggest that you add major donors to the list of categories that you'd look at. We'd also suggest that you audit any committee that leaves at least 20% of the donors blank on their occupation or address. That's usually an indication of money laundering. And every time that you've had a money laundering case that you've looked at, it has been as a result of a large number of donors who are listed without addresses or occupants. And then the third one harkens back to an issue that was raised by us earlier, and that's to ask for an audit of any committee that has been served with a legal notice of violation investigation by a state, city, or federal agency. This, in the past, was precluded because it didn't fit into the pulled out of the hat category. But now we would say that as a policy matter, you would undertake an audit of any group that has received a formal legal notice of violation from a federal, state, or city agency. Thank you.
Thank you.
Bush, may I ask you a question? When you talk about auditing major donors, how do you envision that is done?
What turned out in the past was that there was a major donor who didn't report that they were a major donor and said that, in fact, their donation was intended to be a payment for a contract. And the entity that he was contracting with said, oh, don't pay us in the contract, just make the contribution to our ballot measure committee, which is, he then corrected the forms and did that. And then there was no action taken by the Ethics Commission for a year until the newspapers discovered this in the drawer, and the result was a conviction and resignation for the Chancellor of City College. It was not a one-time thing. It was a pretty serious issue. So what I think the audit would do would be to just check to see a facial audit. Did they fill out the form, and does it show that that it went to this committee? If it didn't go to that committee, but it went somewhere else, what's going on?
Commissioners, Ray Hartz, Director, San Francisco Open Government. In reading the background here, it starts out with audits of campaign committees help provide accountability in city elections by determining the degree to which committees comply with applicable state and city campaign laws. Commissioner Chu was talking about Pareto's principle, which is the 80-20 rule. 80% of your problems come from 20% of your customers, 20% of your customers cause 80% of your problems. So the idea of an audit is to find people who have problems and determine what the real extent of those problems were. Random selection is luck of the draw. And with Pareto's principle, chances are 4 out of 5 of the people you randomly draw will have no problems. Only 1 out of 5 will have a problem, but there will be a number of those. So I would suggest a criteria which is actually, I think, commonsensical. As a targeted audit, select the top 2 or 3 groups in each category who has failed to file their appropriate paperwork on a timely basis throughout the campaign. If somebody has failed on a number of occasions to file their paperwork at all, or has filed it incompletely, or has filed it late, there's a pretty good chance they're sloppy bookkeepers. And if they're sloppy bookkeepers, it's a pretty good chance the audit would hit some pay dirt. So what I'm saying is, rather than taking a luck of the draw, which means 80% of your audits will be finding pretty much nothing except small bookkeeping errors, to pick the 20% who are causing the problems, who are always late on their filings, who are always incomplete in their filings, and then pick 2 or 3 in each of the categories that are in that pattern and look at them for a full audit. Because if you start out with a problem, and if you go through the entire campaign with a series of problems, there's a probably pretty good chance by the time you get to the end, it's a mess. And if the purpose of the audit is to determine whether or not they're following the state and city laws, then it would be best to go after the people who don't follow the state and city laws through the entire campaign process.
Evening, Oliver Luby, appearing on my own behalf. I'm really glad to see this report, and just wanted to let the Commission know that when I was on staff many years ago, I made suggestion along the lines of what your staff are presenting here. It was sort of a combination of this idea, what the prior speaker had said about focusing on campaigns that have violations on the face, such as late filing or contributor information deficiencies, and then lastly, a little bit of randomness. But it's really great to see it move in this direction. And I just also wanted to add a little bit of clarifying remarks to Mr. Bush's comments. There weren't technically audits that were done of major donors, but there was a delinquency canvas for late filings and missing filings that was instituted by the Commission some years ago, and then which was stopped by the Commission staff. And it did turn up a lot of very interesting findings and data that resulted in headlines and ultimately a criminal conviction that was mentioned. And so I would definitely, that's a side issue from actually auditing major donors or their independent expenditure versions, the independent expenditure committees, but it's still another important thing that the Commission can do. Thanks.
Thank you.
Thank you, Commissioners. I think that one of you all raised an important point. In 2005, there was a ballot measure, Prop C, that would have given the Ethics Commission independent counsel and independent budgetary authority. We went out
Giving them what besides council?
independent counsel and its own budgetary independence, budgetary authority.
Oh,
Right,
yeah,
without having to rely on the mayor. We took it out as Prop C in 2005, and it failed 59%. It was terrible. We went into the community and said, we want to get some more funding for ethics to get it beefed up. We want to be able to do this work. And they said, are you kidding? They're nipping at our ankles like for nothing. And we're sitting here having to face all of this independent, all the auditing and oversight for these really small committees where we're looking at the big guys getting away for free. And I think the 80-20 rule kind of applies here in that maybe 80% of your campaigns are going to be grassroots people-funded campaigns, and 20% are going to be the ones you want to look at too. And if you articulate a random audit scheme that hits your potential electorate, as well as the folks who are potentially breaking the rules, that could bode ill looking forward going to the ballot for these matters. We have to prove to San Franciscans that this commission is working on behalf of them, not against them. And last time we went into the field, we saw just the opposite of that. So, for what it's worth.
Thank you.
The best auditing criteria I ever saw was when I was on a platform with another speaker, and I was introducing myself to this gentleman, and he looked at me startled, and he says, "Oh, you're the guy that keeps an eye on a guy like me." And I thought, should I keep an eye on you? Well, later he was indicted, as a matter of fact, and he was eligible for 9 years. He pled. It's a twisted world. But in any event, I would want to ask about slate mailers. And I'd realize that is under the jurisdiction of the Elections Department. I don't know how much auditing they do for slate mailings, if they do any at all, and then who would do them. I wasn't aware that they had necessarily an audit enforcement group that would be doing this type of auditing, which we do. Maybe they defer to the, under maybe Prop C or something under the Controller's Office, I don't know. But that's a question for you as to whether or not you want to transfer the authority, and I think I read that you were interested in looking at that as well. So I just thought I'd mention it to the public.
Any further public comment on this item? All right. Hearing none, we'll then move to agenda item 6, discussion and possible action on legislative proposal by Commission Chair Keane to restore various contribution-related restrictions enacted by Prop J in November 2000. There's an attachment, March 22nd, 2017 cover memo and attachments, and also attachment submitted by me. To begin with, in regard to this item, we're going to take a certain format, if my colleagues will agree, to presenting this tonight. Just capsuled background. Back in 2000, the voters of San Francisco adopted Prop J, which essentially set a number of limits on any kind of gifts or honorariums or any kind of things that were given to public officials. Over the course of the next 3 years, in several measures that were put forth by the Board of Supervisors and also put forth that came from this commission, Prop J was pretty much eviscerated, and it was eviscerated in a secretive way in those 3 measures that were put forward. We'll get the background on them in a little while. The 3 measures dealt with a number of things, and sort of sub rosa had language in them which quite severely limited the definitions of what gifts and contributions were that Prop J had prohibited, and repealed a lot of the language relating to it. It also limited substantially the people who were covered under that in terms of public officials, limited it down to a bare bones, both in terms of what was prohibited and to whom it was prohibited. Over the course of time, a number of groups protested this, mainly the Friends of Ethics and the civil grand jury, which looked at it and said, the voters of San Francisco were deceived by these measures that repealed Prop J without telling them that they were repealing Prop J, that buried these particular things in these various measures, and that should, those things from Prop J should be restored. And back about a year and a half ago, then Chair Rennie appointed me as a committee of one to work to see whether or not those particular measures should be restored, could be restored, and how they should be done. And over the course of that year and a half, a number of other things have come up, but we finally got back to working on it about 6 months or so ago. And I've been working very closely with Friends of Ethics and with the civil grand jury, and particularly with Mr. Bush and with Oliver Luby, a former staff member of this commission. And we've had a number of meetings. One of those meetings, Commissioner Kopp was there and helped out in terms of the vetting of the restoration of Prop J. And you have before you the restoration language of Prop J, along with a chart showing what goes back in and what was in there originally and what it is now in terms of what it was reduced to. What I would like to do is have the presentations of it made tonight by Mr. Luby, who was essentially the drafter of the restored Prop J measure. And the background, so he'll give a presentation, if my colleagues are in agreement with this, as to what it is this measure says. And also then a presentation by Mr. Bush relating to the history and the background, at which time then we'll have discussion. I would not anticipate voting on this tonight because it's such an important measure and should be vetted more by the people of San Francisco. And I would propose that after we discuss it here tonight amongst us and members of the public, that we, over the course of the next few weeks, set several interested persons meetings, then come back next time and look at it again in terms of whether we're ready with a final version of this to vote on. If there's further discussion the next time and we want to refine it some more, then we'll put it over, we'll come back the meeting after that. There's no reason to rush with that. We should take our time on this to do it correctly. We've had a certain amount of attention, which has been excellent so far. Mr. Bush and I wrote an op-ed piece for the San Francisco Chronicle, which they published last Monday. On Friday, the San Francisco Chronicle wrote an editorial very much enthusiastically agreeing that this should be done by the Ethics Commission. So I would imagine we'll get more coverage as time goes by and have a full discussion and eventually adopt something that we should. So with that, if I have the permission of my colleagues, I'd like to start the presentations from Mr. Luby.
Good evening, Commissioners. Oliver Luby. One of the things that 2000's Prop J did was ban officials who approved contracts from receiving contributions from the contractors. A section in the CFRO, the Campaign Finance Reform Ordinance, 1.126, does the exact same thing. So each has essentially the same fundamentals. Both address the intersection between money and public decisions. Both block quid pro quo. We wanted the Prop J restoration drafting to avoid overlap with existing code and utilize its architecture. The primary idea was to extend 1.126 to cover public decisions besides contracts, and not just contributions, but what Prop J called personal or campaign advantage. Or in plain English, it's the various financial incentives that fall short of bribes, but that yet still can influence decision makers or create the appearance of that influence. The draft includes amendments to 6 CFRO sections. One is 1.122, and part of another 1.170 subsection I3 are the only changes that aren't technically derived from a J restoration, but are still prudent reforms that dovetail with J. To summarize those two really quickly, 1.122 consists of two changes: restoration of another thing that was deleted from CFRO, a prohibition on transfers between controlled committees not formed for the same office. This is essentially consumer protection for campaign contributors and would prevent things such as excess funds in a ballot measure campaign for a popular measure suddenly going into a campaign for re-election to or election to a higher office by the same controlling office holder. Then the other part is a commissioner and department head contribution and fundraising ban that was copied from LA law. As for the subsection I3 of 1.170, it essentially just copies LA law, allowing a court to impose, in addition to whatever criminal conviction penalty it would impose for a CFRO violation, also a 4-year ban on serving as a lobbyist or a contractor. It's in LA law. As for the J restoration effort, the comparison table in your packet contrasts J, current law, and the proposed amendment, which we think of as sort of J but better. The J highlights first, CFRO's private attorney general provision in 1.168 is expanded to include suits for penalties for the most significant violations. Second, the penalties section has edits that give 1.126 violations parity with other CFRO violations. So the maximum penalty would go, instead of being up to $5,000, it would be up to the greater of $5,000 or triple the amount of the amount illegally provided or received. Similar to your contribution limit violations. And then third, and most importantly, the amendment extends the scope of 1.126's key elements, including the personal or campaign advantage that is prohibited, the official's specific interests that may not be receive the advantage, sort of the sphere of influence of the official, the person prohibited from providing the advantage, the prohibition period, the decision maker that triggers the prohibition, and the types of public benefit decisions that trigger the prohibition. In 2006, 1.126 was extended some of its key elements. It was a major reform that the Commission initiated in 2006. And the Prop J restoration also takes this kind of path. Any type of major public benefit decision, not just contract awards, can have quid pro quo problems. Any campaign or personal advantage, not just contributions, should be prohibited in that case. The restrictions on persons seeking a public benefit should it should include not only its officers and owners, but their agents and any person with a financial interest in the benefit. And public benefits provided by the appointees of elected officials don't require scrutiny just because the appointees happen to run a state agency. A decision by anyone appointed by or subordinate to an elected official raises the same level of concern. In addition, the amendment includes some other changes to 1.126. Two major ones: a disqualification provision based on the city of Richmond's law, which is the flip side to the main prohibition. Essentially, if an official has already received the personal or campaign advantage, they can't then make a decision for the benefit of the donor for 12 months. And then there's also a debarment provision, which was recommended by the Campaign Legal Center and creates another consequence for 1.126 violators and is also based on LA law. I'm happy to answer questions.
I think what we'll do is we'll complete the presentation by Mr. Bush, and then at that point, Commissioners, I'd ask if you have any questions of either Mr. Luby or Mr. Bush.
Thank you, Chair Keane. This has been a multi-year effort on the part of a number of people. It began with the passage of Prop J in the year 2000, which was done by a petition from a group called the Oaks Project, which they did it in several different cities. San Francisco passed it with 83% of the vote. Over the next several years, the Ethics Commission decided to rewrite a number of ethics laws. And one of the things that they did was to say this was essentially a ban on contractor contributions. And so they wiped out everything else in a reform that passed in 2003, but it was sort of slipped in to an overall reform of ethics laws. And in the process of doing that, they did not tell the Commission that one of the impacts of their reform was to delete all of the provisions of Prop J. Nor did they tell that to the Board of Supervisors, nor was that put into the voter handbook. They described the other things that it would do. There was a throwaway line that says, we're going to go back and refer to some of these other issues later on, but of course that never happened. Following all of that, as we looked at it, we took a look at an evaluation by Harvey Rose, the board budget analyst, on comparing San Francisco and Los Angeles ethics laws. Saw that there were a number of provisions in LA that don't exist in San Francisco, and which Harvey Rose recommended that we might consider here in San Francisco. They were very close to what was already in the earlier Prop J. We work with the Campaign Law Center in Washington, D.C. to make sure that what we were looking at comported with later judicial decisions. We had the participation of former commissioners, including commissioners who sat on the commission when Prop J was passed in 2000, and who sat on the commission in 2003 when it was eviscerated. And we worked with people like Randy Riddle, who wrote the provision in Richmond that Oliver Luby just mentioned, as well as Bob Stern, who was the co-author of the Political Reform Act. My point in reciting all this is to say we took a very sober and serious look at what it is that was going on. It involves everything from franchise agreements to development permits. It takes a look at the fact that, in an amazing loophole, while contractors are banned from giving contributions, they're not banned from being fundraisers. And so just as long as they don't put their own check in the stack, they can go out and raise money for everybody else. This closes a lot of those loopholes. So as we looked through it, what we found was that millions of dollars has passed through these various loopholes to the benefit or at the request of officials who made decisions that had a financial advantage to the people who made the donations. And when I say millions, I mean in one category alone in the last 2 years, it's been $10 million. And mostly in contributions of $1 million or more. There was people who had major projects. So the question then comes, what difference would this make? And what we know is that as public confidence in political decisions increases, people are more likely to participate and feel like those decisions reflect their values and their interest, rather than that they have been left aside by people who have special interest. So we see this as reaching the overall goal of what we're doing, as well as dealing specifically with the things that have created distrust that City Hall decisions are being made for the interest of the few instead of the many. Thank you.
Thank you, Mr. Bush. Commissioners, at your pleasure, any questions that you may have of either Mr. Bush or Mr. Luby, or comments?
I have a couple questions that maybe Mr. Luby can respond to, or Mr. Bush, or Mr. Keane. Just going to, just a couple questions that I had as I read this over. Going to page of this red line draft, the Restoration Anti-Corruption Act, in section 1.126. What was the thinking of using a $50,000 threshold rather than some lesser amount or some greater amount?
Well, the threshold actually varies. I mean, there's an existing $50,000 threshold in the 1.126 for contracts. It's the disclosure threshold, and I believe your former staff are actually not too fond of it and tried a couple times to increase the threshold despite some public opposition. It does trigger more disclosures of contracts by the mayor's office, the board, the city attorney, et cetera. It's one of the side effects of the 2006 amendment, and without getting into the weeds too much, it would probably be good if at some point if the city and county switched from a disclosure system with filing reports with ethics to an integrated campaign finance and city contract database so that the filings are automated. And that's kind of addressed actually by one of the subsections in the notification section. But getting back to your question, the original Prop J had different threshold amounts for different types of matters. And we made some effort to sort of honor those original amounts. If you'll notice, one of the threshold amounts is 0, which is the threshold amount in a similar proposed law that's coming from one of the supervisors, and this sort of mirrors that with regards to land use, but then has a caveat that some of the land use decisions wouldn't be covered unless the amount of value of the land decision is, I think, $1 million or more. So that was sort of the thinking that went into it. There might be a better way to do it, and hopefully if someone has bright ideas, either at the staff or city attorney or interested persons level review, that'll come out and inform.
Okay, thank you. And then
Sure.
going on to the next page, under definitions, board. And I've got to say, I just didn't quite understand. It says, board on which an individual serves means the board to which the officer was elected or any other board on which the elected officer serves. What about a commissioner who isn't elected? Doesn't he sit on a board?
They do. This wouldn't directly, I don't think this term was meant to, this term, I believe, is actually in the original law, and
Right.
I think it was meant to refer to the member of the Board of Supervisors specifically, or possibly at one of the state appointees. I'd have to look and again, refresh my recollection about how that term's used in the original law, but I think it's used under the prohibition section where they refer to, yes, under B1A, approved by such individual, which is the individual holding city elective office, the board in which the individual serves. So it's a board in which the elected official serves, and then it goes on to the state appointees on state boards. We broaden that to include appointees or subordinates of that individual. So a commissioner who makes a decision regarding a public benefit, and that even could be this commission in theory, they would trigger the new Prop J because it covers any appointee, not just appointees to state or appointees to state bodies such as the Treasure Island Development Authority or the former Redevelopment Commission. But as this term is used, I think it only gets used in the context of the Board of Supervisors.
All right. And then going a number of pages on to the debarment section. G.
Uh-huh.
I was just curious, it looks like if the Ethics Commission were to find that an individual is identified in a debarment notice, that it isn't an automatic doesn't automatically disqualify him from him or her from going forward with a contract, right?
Correct.
So that the ultimate decision maker in that case is the contracting officer or agency?
That's my understanding of this is almost word for word. Well, it's very similar to the Los Angeles law on which it's based, and that's my understanding of how it works in LA.
I mean, my concern would be that in effect, one could be found to have violated, but the city agency could say, well, these guys are too important as far as contractors, and so we're going to ignore it.
That occurred to me as well, and the reason we didn't change it, we, to be totally frank, didn't have the time to totally research all the legislative history that went into this. It's something that I'm hoping, since you have your director as a former director of the guardian of this law in Los Angeles, that she might have some familiarity with the reasoning behind it. But what also occurred to us was that there may be situations where there are legal problems if debarment's automatic.
That's all I have, and thank you for your efforts.
I want to thank Mr. Luby.
Any other questions for either Mr. Luby or Mr. Bush? I thank you both as well. We'll now take public comment in regard to this item.
Commissioners, Ray Hartz, Director, San Francisco Open Government. As I was reading that section that Commissioner Rennie questioned, Section 3, these don't have page numbers, so it's kind of hard to reference it. It says, board on which an individual serves means the board to which the officer was elected and any other board on which the elected officer serves. And I think, as was mentioned by the speakers, that probably relates to the Board of Supervisors, who will select members of the Board of Supervisors to serve on the Golden Gate Transit Board and other various commissions and boards. So it basically says that if I'm a member of the Board of Supervisors, I am prohibited in my direct position as an elected official and member of the Board of Supervisors from violating these tenets. But it also means that if I happen to be on another board to which I have been appointed by my fellow board members, and someone comes before me with whom I've had financial dealings or relationships, I would be prohibited also from them. It wouldn't be sort of like there's a firewall there, and since I'm not really dealing with this person on this matter at this board I've been appointed to, I could sort of kind of look the other way. It becomes a very convoluted matter. And one of the things that I have learned over the last 8 years of looking at the Friends of the San Francisco Public Library is that the bodies who authorize these kinds of arrangements will go to immense lengths to hide and withhold public records and anything that will provide evidence to document either one of two things. One being documents that show wrongdoing, or more frequently, documents which cannot be produced because they're not available and as a result show that the people are not doing their job. For one example, the orders of determination I had related to the matter had to do with the Board of Supervisors. One this body heard against Eric Marr. I asked Eric Marr, when he sat on the committee that approved the annual gift from the Friends, I would like to have copies of any documents that you or any member of your staff looked at when deciding on how to vote on this matter. And he refused to answer. He refused to give me any documents. He refused to say he didn't have anything. And it was the same thing with Mark Farrell. If I'm the head of a Board of Supervisors subcommittee and I have to admit to the public that I authorized and voted on and recommended to the full board approval of something that neither I nor any member of my staff even looked at, that basically is an admission that I didn't do my job. And it may be something that goes on in government all the time, but it's unacceptable. If I am voting on something, especially if my fellow board members are going to rely on my recommendation, I have an obligation to have someone look at the documents.
Thank you.
If I could just correct my prior comment, a board in which the individual serves would also include the Board of Education and the Community College Board. And again, the reason the term exists in the current law is because some contracts are approved directly by an elected official and some are approved by a board of elected officials. So that's why the term exists.
Yes, Commissioners, Mark Solomon. When I first got involved in politics, I knew nothing of land use and I really didn't care about it. But being involved in politics in San Francisco, it centers around land use because that's where the money is, that's where all the action is. 80% of the problem is not land use, the 20% of the problem that is going to cause you 80% of the work. And as I got involved in this, I began to see exactly how the money played, how it flowed, how it influenced campaigns that I've worked on and against, and how it changed the very face of my community and basically caused possibly 5,000 families to become displaced from the Mission District because the government was serving the people that were paying their bills, not the people who vote for them. And I think that's a problem. In doing my work on Prop J analysis with the Planning Department pipeline data that there were, the 20%, and the campaign finance data, there was some overlap with developers, but it's really the ongoing permanent political class that one might call the spur class of the consultants to the developers, the attorneys to the developers, their architects, and various other people who exist from project to project. One developer might come in and do a project every year or two or three, while the same people are always doing the work to go ahead and make sure that the water is carried from step to step. And that's where I believe the corruption comes in, is that it's almost like permit expedition, but for long-term project expedition and facilitation, that we have to go ahead and get these same people whose name pops up over and over again to be sure that when they start to contribute, anyone who's hired them is frozen out. Anybody who's received a contribution from them is frozen out. So we divide this wall here between campaign spending and public policy. It's going to be tough to do. I think you'll get immense public support from it. But the extent to which we see government totally driven by this is just universal. I've had to pack my head with the California Environmental Quality Act and the Planning Code just to be able to understand what they're doing to our communities. And that's an immense amount of wasted brain cell space that could have been used for productive uses. Yet here we are living in San Francisco. And with the current case that's going to court, every time I see a crane above one of these new buildings, there was probably a Zula Jones, Keith Jackson, what's her name, Majaher event that went on to go ahead and grease the skids, to make those contributions, to say, hey, we know how we do business here in San Francisco, we do it right. So every one of these every one of these development projects we're seeing, something like that had to go on. These things don't happen for nothing. Willie isn't worth several $100 million now for nothing. And there's an ongoing criminal, corrupt class in this city that is changing the face of this neighborhood in a way that has systematically excluded residents from any participation in the development of our communities. And as I live in the Mission District, safe and secure in my home, people are popping out of existence in the community around me, and it's disconcerting to me. We're seeing families displaced. So this has a real human factor here that this commission needs to go ahead and restate the voters' Prop J law to cover all of this. Thank you.
Thank you.
Charles Marsteller again. I wanted to say this. This city has changed dramatically in politics since Mayor Brown left office, or even while he was mayor. And we had basically a fairly standard series of political events occurring in the city, but we seem to have gone on steroids. And clearly, we had to look at the much broader spectrum of dynamics that we saw that were being abused, particularly in land use and contracting, that's tied to our elected officials and their decision making. And in the early days, you go into campaign finance and you go into campaign finance. But now we realize campaign finances in this town is all about land use. And it's likely that when we do our data analysis, as we are attempting to do, if we can get the data, we're going to see that 90% or 80% of the money is really connected to permits or developers seeking permits. And I think Mr. Solomon is right when he says there's $1 million for every boom crane you see on the horizon in San Francisco. And it's not going into the pockets of the city. There are obviously consultants or consulting attorneys involved. And a prominent planner, I won't mention who, in the history of this city, told me that essentially there's a handful of key players with all things in San Francisco, and they overlap with just about everything that involves money, and particularly big money. So it boils down to a handful of people, and if we identify that cadre of 20, 30, or 40 people that are basically running land use in this town, we're going to basically come to 80% of the money flow. So maybe more. She said 90. But in any event, I'm very glad to see this broadening of Prop J. It was good when it was written in 2000 or before that, but it's certainly updated by Mr. Luby's work, and for that I thank him. These tables say a heck of a lot, and these blocks showing you the dynamics. Every one of these items in land use follow money.
Thank you.
Good evening, Commissioners. My name is Craig Weber. I'm a native San Franciscan. I live in the Mission District. I served 2 years on the civil grand jury, 2009 and 2010. I was the committee chair for the investigation of pensions in San Francisco, which, as it turned out, was one of the most, in my opinion, the most important investigative report done by the civil grand jury in San Francisco in the last 20 years. It resulted in at least 2 initiatives on pension reform in 2010, 2009. It also was an important part of Jeff Adachi's campaign for mayor at the time, the only public official that would stand up to the three most powerful groups in San Francisco, and that is the SEIU, the Police Officers Association, the Firefighters Union. My point in bringing this up is I'm a novice to this whole political process in San Francisco, and that was my first exposure to how abusive government can be, and how few public officials will actually challenge the system. Recently, the editorial or the op-ed that Commissioner Keane and Larry Holmes edited for the Chronicle brought me here tonight. That, and also on the same day that your op-ed appeared in the Chronicle, there was an article on land use, and that involved Lennar Corporation and the arrangement that a nonprofit organization in the Mission called Calle 24 has worked out with, has brought an appeal in effect against Lennar, and was passed by a motion by Supervisor Campos in his literally last meeting as a board member to basically block development in the Mission and block Lennar, and also block Axis Development, which is trying to build inclusionary housing on Folsom and 23rd Street. This is the type of tactics that you didn't address in your editorial, and that is the role of nonprofit organizations who will block or provide some support for members of the Board of Supervisors. I had to literally go to Lennar and threaten and buy one share of Lennar Corporation stock and advise them that as a shareholder, I will go to their audit committee at the corporate headquarters with a complaint, and I will instigate an investigation. Guess what Lennar did in San Francisco? They backed off very, very quickly. They went to their general counsel and they got advice on how to structure this deal where not $1 will go to this nonprofit organization or to a member of the Board of Supervisors, in this case, Hillary Rodin. Thank you, and thank you for your service, both in particular Commissioner Kopp, who I remember in the early days on the Board of Supervisors with Barbara Gelada, two key people in the history of San Francisco that served the citizens well. And thank you, Mr. Keane, for all your public service. I just hope your legacy here in San Francisco will be to bring campaign finance back to a status where we can trust the process. And I hope you build the enforcement and that you don't have to rely on public members, public citizens in San Francisco to basically take up the enforcement that perhaps your commission should follow. But thank you very much.
Thank you, sir. Any further public comment?
Hello. Thank you for allowing me to speak. My name is Kieran Lau. I live in the Dogpatch neighborhood in San Francisco. I'm part of a group called Represent Us that was working with the commission and on Prop T. I want to talk a little bit about land use in my neighborhood in Dogpatch. We were a mixed-use neighborhood with a lot of commercial industrial zoning, and all of that is being torn down right now and being turned into the maximum density housing that is available in that neighborhood. We have over 30 construction projects in a neighborhood that's only about 4 blocks by 8 blocks wide. The total population over a course of about 8 years will increase probably tenfold. We're probably the most densely populated, and we've seen the influence of developers and their ability to get things done in that neighborhood, and in some cases, in particular, we're being impacted by the Warrior Stadium. And I went to these public meetings, and I walk in, and I see 20 people in suits, highly paid lawyers, highly paid consultants who are helping to get these things. And some of them are also along the staff, Mayor Lee's staff, and San Francisco city employees who are helping to facilitate the incredible speed and rate that development is being built. I'm now also dealing with UCSF, who's moving into our neighborhood, into a residential neighborhood, and they know that they can get things done at an accelerated rate. Part of that is simply because they can offer jobs to people in the process further along in their careers. They don't have to follow city rules because they're a state agency, and so that we see the power of these large billion-dollar institutions that are using to grease things and to do development and to get, in some cases, hundreds of millions of dollars worth of development done quickly. So I would encourage you, for residents like me, I have to forgo any thought of being able to live in San Francisco long term, because I know that I'm at the whim of a developer or a community of developers that are able to influence the decision and to push us out. And I have a 5-year-old daughter here, and I'd love to have her to stay and be a resident in San Francisco. And certainly to some extent I could stay here, but there's just so much pressure to push all of us out to make effectively what's luxury housing for the elite to stay here. So I'd encourage you to put these kinds of things in, allow us to slow down some of the profit making in favor of building families and communities and making it possible for some of us to stay and live in San Francisco a long time. Thank you very much.
Thank you.
Good evening, Elena Schmidt. I'm not going to speak about land use or actually the content very much. All I want to comment on is the process. So I was the foreperson of the civil grand jury that had done the 1213 ethics report. There had been one earlier, maybe 910 or 1011, which was called the Sleeping Watchdog. We were the ones that looked at what happened to Prop J. There are a number of issues that we looked at for the Ethics Commission, but the work that took the longest time was to figure out what happened and how did it happen that Prop J had basically disappeared. And we went back to the archives, we looked at all the minutes, we looked at all the legislative history that was there, and as Mr. Bush had indicated earlier, there was nothing where the commissioners themselves did not understand what they were voting on, or that the Board of Supervisors did not understand what they were voting on. So basically, I'm here to say this is a great process. We're getting the words out there. Everybody's going to understand what this is all about. And I think that that is part of what this all represents, is bringing transparency to your process as well as transparency for the citizens to know what the candidates are doing. So thank you for that.
Thank you. Any further public comment? Or commissioners, any further discussion by the commission? Commissioner Cobb.
Well, I want to thank everybody who participated in the promulgation. Mr. Bush, of course, Mr. Luby, but also those who have taken time to give their attention to us. And I am ready, Mr. Chairman, to move that this commission submit to the Board of Supervisors as soon as possible all of these recommendations. But I know that in your almost infinite wisdom, you rightly, justifiably point out that we should ensure that it's done in a measured way which gives other people and other organizations an opportunity to be heard publicly and to be heard with the staff or with individual commissioners without violating any law. But I'm satisfied with what lawyers call the work product. Thank you.
Thank you, Commissioner.
I would echo what Pop has just said. I think we ought to take some action tentatively adopting this, then going out to the public for comment, to then come back to us for final approval. And I see that the executive director is raising her finger, so I must be doing something wrong.
Not at all, but I'm happy to comment when you've had a chance to, if other commissioners wanted to chime in. I just have a process observation.
I could add, Mr. Chairman, if I may, tentative approval might be the term which could be utilized, Commissioner Runny.
Well, since you're looking at me, I will take the moment then to chime in. Thank you for that opportunity. I would love to take this time to remind the Commission of the success of Prop T last year with the lobbying provisions that were put before the voters. It reminds me of some of the discussion in the room today, and that I think there is an important process to be followed of transparency, as the speakers have said, and to really make sure that this Commission does its work in vetting the proposals in a way that we can make sure are strong and clear and enforceable as we take issues to the board, to the voters directly. And so in that process, I would encourage the Commission to allow us to do our job at your staff level as well, to make sure that we have an opportunity to do thorough and thoughtful interested persons meetings with information both about what's been proposed here, additional information to really bring out as much public comment as we can. It is clearly our goal, as it is yours and it is the public's, to make sure that our laws are strong and workable and enforceable. And this is not code for slowing down the process or for gutting what is launching a process to make our laws more effective. But I do think it's very, very critical that the practice you've started on in the past year of really using your staff to help you with this process is a really critical one. And we would ask for that opportunity to make sure this is a good, strong process.
I've got to say, I didn't think anything that I said or that Commissioner Kopp said in any way interferes with the process that you're suggesting. I assume you would do that. Is that you will vet it, you will have your interested persons meeting, and maybe a commissioner or two will appear at some of those so they can hear what the public commented, and you'll come back to us with suggested changes or revisions, or you'll say, no, it's fine as it is. And what I thought Commissioner Kopp was doing is trying to express the support of the Commission to the proposed legislation, subject to public comment and everything else, and coming back to us with a recommended sort of final version for our then consideration to see what changes should be made. That's all I'm suggesting.
And I understand that, and I think the question that I would ask for some clarity on is the time frame. I think Chair Keane, you were suggesting that you would like to see it come back next month, have some interested persons meetings between now and then, and I believe that's going to be extraordinarily difficult to do the process well for the Commission. So if we can have some additional conversations about the time frame for bringing it back, we understand it's a priority and we want to meet that, but we want to make sure that it's a time frame that serves that purpose.
My feeling is that over the course of the next few weeks, we should have those interested persons meeting. Next time we come back, have the staff weigh in on it to the extent that you're prepared to weigh in on it. If you need extra time, we'll go to the next meeting in terms of getting your final analysis relating to it. I'd also like next time the city attorney to go ahead and vet it and give their opinions as well. And so we should meet. I recognize and appreciate Commissioner Rennie and Commissioner Kopp's desire to go ahead and express tentative approval. I think we're all doing that. But I think what we want to do, we should do, is to keep the process really straightforward, is go through this vetting and writing and rewriting process, and then either next time or the time after that, have a finished product, and one of the commissioners will move to introduce that. We vote on it, and then send it to the board. But there's no reason to vote now on anything. I think the expressions of tentative approval are well put and certainly welcome. But I think if it's, my colleagues agree, that's kind of the track that I'd like to put it on now.
Can I ask one question?
Commissioner Rennie.
As I understand it, we are down a track where we aren't going to put this on at the 2019 election. There's no 2018 election. But we're going to submit it to the Board of Supervisors for their adoption, which causes me to say, ask Commissioner Kopp, shouldn't we or the staff be doing some work with the board or the board staff to get some input from them before we send something to the board that we want them to approve?
Well, I think that can be done in the period between now and April 27th or whatever it is. I'm certainly able to confer with individual members of the Board of Supervisors.
I think that's good.
And I'll keep notes so that I don't forget at the next meeting.
I think we should definitely do that. I would, I don't want to prejudge anything, but I think in the event that this is, one of the things that this does is this sort of cramps the style of a lot of elected officials in San Francisco in terms of raising money and doing various things, certainly board members as well. And whether or not they're going to jump at it with enthusiasm, hopefully they will, but, you know, I don't know. So in that situation, what I'm looking for is that when we do send it on to the board, we send it on to the board telling them, we want you to adopt this or substantially adopt this, and you can make a few changes, but substantially adopt this within 90 days, and the mayor sign it, or we are going to put it on the ballot for next year, for the 2018 election. And then, because maybe I shouldn't say this, but I don't expect a lot of enthusiasm out of the Board of Supervisors relating to this measure, which is going to sort of sew up their pockets in a number of respects.
You mean my appointing authority? I know you're not personalizing it.
No, I'm not. Anyway, I hope I'm wrong, and everybody looks at it with an objective and detached view.
Well, I think that 90-day thought is mandatory for us.
Yes.
And of course, the city attorney's office is happy to, work with the commission and work with staff. We just saw this, at the same time that you all did. This is an extremely complicated ordinance. It does a lot more than what Prop J did. For us to do sort of the type of analysis that we'd want to do to raise legal issues, I think would require more than just the time between now and the next meeting. If there are legal issues, of course, we don't present those to you in public. There may have to, if there are legal issues, we would want to put them in, in memo form, as is consistent with our practice. So I would just say that we want to do, the thorough analysis that's required of an ordinance like this, and we would just ask that this not be, rushed. And I really don't think that the time between now and next meeting is sufficient for our purposes.
Well, I want you to know that we'll have to do it without you if it takes too long.
I think Commissioner Kopp makes a point there that rather than just draw this out, I mean, it's complicated, but it's also very straightforward in regard to what we're doing here. There may be some twists to it that should be looked at, tweaked, but we have people, we've talked about, Mr. Bush has talked about Mr. Stern, and experts in ethics all over the country have fashioned similar things to what we have and recommend this. And so I don't think it takes a great deal more study by the city attorney's office we'd like your input if by next time. If you need to go to the meeting after that, I think we'd probably be willing to do that. Beyond that, though, my sense is we're gonna vote this up or down, send it to the Board of Supervisors, and move it forward. We should. The last thing we want to do is just sit on it or bake it for too long. Commissioner Chu.
I would propose then that the staff and the city attorney move as expeditiously as possible to conduct interested persons meetings and to do the legal analysis, and not to rush you, but I think that what I'm hearing and I share is a lot of support and a sense of urgency around this measure because it's, I think, a harm done that we want to address immediately or as expeditiously as possible, not immediately. So I would ask that I would propose to my fellow commissioners that the work be undertaken in the following month, and that at the next meeting we'll hear from staff and from the city attorney as to where we stand in terms of the interested persons outreach, as well as the input and a revised draft, as well as the legal analysis, so that we can then formulate a decision as to whether we can act at the next meeting, or if it's going to be taking a little bit longer, but understanding that this is of a top priority, I think, for the Commission.
Yeah, I mean, as always, we'll do our best. We're not trying to sandbag you or anything. I mean, this is just we literally just got the red line the other day, and we'll do what we can. That's all I would say.
Okay. Any further comment on this matter from the?
I might say, in fairness to the staff, he pointed out at the very beginning that it was a year and a half ago when I appointed you as a committee of one to look into this, and we're hearing it now, and
I moved with my usual lightning speed, which
Anyway.
in this case took about a year and a half, but that's pretty fast for me, actually. All right, so I think we all have a sense of where we are with this, and so we'll take it up again at our next meeting. Let's move on now to item number 7, discussion of staff's education and compliance report, a periodic update on various programmatic and operational highlights of the Education and Compliance Division, with attachments of March 22nd, 2017 staff report and attachments.
Great, thank you. Thank you, Chair Keane. Pat Peterson from our Education and Compliance Group put together this report as a brief overview of activities that have been the focus of our work over the past month. Primarily, we have been focused on supporting city employees who are designated filers for their upcoming Form 700 filing process deadline, which is Monday, April the 3rd. I'll say it again, Monday, April the 3rd is the deadline for Form 700 filing, to remind myself and others who have that obligation to make sure that we submit our documents on time. And we have a very cool e-filing system for elected officials, board and commission members, and department heads to help accomplish that requirement. But we have been having a series of meetings. The last of them, we added one last session for filers last Friday to try and help people understand the requirements of the Form 700, the process, and what kinds of tools and resources we've been putting together to help them do that. And so that attached for your reference and for public information were the slide deck from those presentations. Again, we continue to use our website to try and highlight key issues. We'll be very interested to report back to you in future reports about the use patterns that we've seen with the tools and resources we're providing online to help folks with their filing obligations and other issues. So this was a status report, an update for you, and happy to answer any questions.
Commissioner Chu.
Yes, Director Pelham, at last meeting you had noted there was a high number, thousands, I think, of paper filers.
Yes.
Do you expect that number to stay the same or decrease and more people transition to e-filing this year?
At this point, it looks like that number would be pretty static. There is a biennial review process that departments engaged in this year, and so the numbers that resulted from that are likely to be the numbers that we would move into 2018 with. That said, we are also continuing to be in conversation with departments about tailoring categories and disclosure designated employees listed so that it is in sync with state law, and that they're fully aware of the basis for having somebody listed as a designated filer. So that may change, but I think the rough numbers are the same.
Thank you.
Any public comment on this item?
Commissioners, Ray Hartz, Director, San Francisco Open Government. I did training for the Commander-in-Chief Pacific Fleet for 4 years while I was in the Navy. I spent 14 years teaching for the University of Hawaii and 3 years teaching for American International Group, one of the largest insurance companies in the world. And when I look at this report, I basically see a form for how to fill out the form, when to check it, what the fines are. But the fatal flaw in the training effort regarding Statements of Economic Interest Form 700 annual filings is that there appears to be no discussion or penalty for filing false statements. Documents are submitted under penalty of perjury, as we saw in my earlier comments, but there is no penalty for lying. City Librarian Luis Herrera, a city department head, was brought to the attention of the Ethics Commission, which ignored the complaint. Individual citizens had to take Herrera to the FPPC in Sacramento to get action. Of the 33 orders of determination that I hold from the Sunshine Ordinance Task Force, 2/3 of them concern the Friends of the San Francisco Public Library and the millions of dollars they have flowing through their coffers every year, little of which actually goes to benefit the library, which is supposedly who they are the friends of. If this training is simply done to tell people, here's how you fill out the forms, and once you get the forms, you put them into a file, and that's the end of the story, well, then that's the be-all and end-all. Fill out the forms. They don't have to be true. You can lie. And even if citizens catch you in the lie and go through public records requests and get documents that prove you're lying, you can bring it to us, and we'll ignore it. That's been the history. Am I saying that's the way it's going to continue? I hope to God not. I don't think it was right that small group of us had to take the city librarian to Sacramento to get him to correct his falsely filed SEIs. And yet what I see in this is really nothing that points to any indication other than if you want to make all those required file aware, they can lie without consequence. In other words, it's a matter of filling out the form, nothing more. You can lie on it, you can sign it under a penalty of perjury and lie on it, and they won't do a darn thing to you. And unless there is something done to actually show folks that when they file these, somebody's going to review them, and if they're wrong, somebody's going to do something about it, then it's just nothing but a pointless exercise and a waste of paperwork, which you always seem to be concerned about.
I laud the effort by the Commission to get this system of electronic filing spread to all parties, not just the top strata of the 700 filers. And I'm hopeful that we'll get that legislation through the board. I did have a question. If it fails at the board, are you prepared to take it, or can you take it to the ballot? I don't know. Because things do have a tendency when they affect personnel sometimes to slow down at the board. To wit, the whistleblower ordinance, which seems to be pretty dead in the water. I shouldn't say DOA, but it's pretty well stayed in the water right now, and it's been there a while. And this might be the same problem. But I do think that the employees may not have to lie if those papers are lying in a file for them. Not to be too clever, but I'm thinking that that's essentially the bottom line. There's going to be less people looking at the paper than obviously doing searches on the internet. And I think that that's the rub. So let's see what we can do to get the bill through the board, I think. And that if they're not going to do it, then somebody's got to put it on the ballot.
Commissioners, I just want to note from my own experience of tracking other people's filings and doing my own filings that this is essentially a state requirement that ethics takes on. And as a state requirement, the most that you can do is a $100 fine, which is $10 for a 10-day delay. So if somebody is a year late turning their report in, it's still $100. Unless at a local level, you enact something to add to the penalty that the state would give. And some jurisdictions do add additional penalties. The fact that this is going to become electronic is going to make things much easier to understand where people's interests are. Just simple things like how many city commissioners have PG&E stock, or how many commissioners have spouses who have businesses that contract with the city, which is something that we see going on now out of the Franchise Tax Board. Thank you.
Okay, hearing no further public comment, we'll now move on to agenda item number 8, discussion of staff's enforcement report, an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting, with attachments from March 22nd, 2017, enforcement report and attachments.
Thank you, Commissioners. The main programmatic highlights are that I have been attending a training for supervisors that's put on by the city. It's called 24 Hour Plus because it's 24 hours of training in total, I think, or maybe it's a little more than 24 hours. But it's every Tuesday during the month of March with training modules in the interim. It's been very helpful and very good training, and I'm very happy and honored to have been able to go. So I just wanted to report that to you. I've also been collaborating with Leanne and our fines collection officer and researching other enforcement policies that are publicly available, like at the FPPC and the FEC, to come up with a set of enforcement procedures for our internal handling of complaints as they come in. We're setting timeframes internally for when we expect our new investigators to have preliminary review completed, for what approvals are going to be needed by myself and when Leanne needs to be involved, and when we need to bring things to the commission, what types of reports need to be drafted, and the timeframes for those. The goal is to shorten the investigation's timeframe that has taken in the past, and to really expedite preliminary reviews so that it's not a longer process that's similar to the in the past. It's been roughly the same time frame has been dedicated to preliminary review as the investigation itself. So we're trying to shorten that. So that's been sort of the goal. And we're also, my next up on my agenda in terms of preparing the enforcement program for the arrival of our new investigators is to refine and revise some templates that I have been developing and finalize them so that they're ready for when the new investigators arrive for training purposes. This month I also attended a Sunshine Ordinance Task Force hearing about a complaint that was filed by Mr. Hartz against Judge Kopp, alleging that he abridged his public comment time. The task force found that his public comment time was abridged by 7 to 8 seconds and found the commission in violation of the Sunshine Ordinance. I believe the order of determination is attached at attachment number 3 if you'd like to look at it. In terms of operational updates and investigative caseload data, you'll notice that our investigations, our open investigations has remained static at 24. Our preliminary review complaints saw a slight uptick to 100, and I think we're at 113 or so now, 122 now. And then I also wanted to note that last month we made an error, a clerical error of sorts, in calculating the number of matters in preliminary review on our February enforcement data report, the attachments, and so we've included a revised report for February as attachment 2, in addition to the March numbers, so that you have all of the data, accurate data in front of you. We apologize for that error and note that that type of reporting of those numbers will be standardized as soon as we are able to implement the case management system that we are still researching. And I forgot to include an update on that, but on that front, we are reviewing another software application with the Controller's Office this week. And so we're excited about that opportunity. There's potential for collaboration there, and we're excited about that opportunity. So thank you.
Commissioner Chu.
Director Pelham, is it possible that there would be case management software installed or purchased this fiscal year with some of the additional funds that we've had from salary savings?
I think it's possible, but I'm hesitant to be very firm about that because I'm learning that money, purchase orders and procurement items take a bit longer than I anticipate. So I don't have a deadline for you, but we are working. It's something that Jessica is in regular contact with lots of folks about every opportunity. So we're aggressively pursuing that, but we just don't have a deadline yet.
But even if it's not done this fiscal year, will we have the funds in the upcoming fiscal year to be able to make the investment?
We are making that case as part of our budget, and we also may have some flexibility to use funds this year. So that's why we're trying to keep it in the forefront.
Yeah, may I ask maybe the city attorney, the Sunshine Ordinance Task Force said, as I read the report, that under the public comment provisions, the commission cannot interrupt during the public comment, whether it's a 2-minute period or a 3-minute period, and that our violation was the fact that there was some interruption which caused 8 seconds to be lost. But the underlying statement that under the right of public comment, the commissioners or the board or anybody else is not allowed to ask questions or intervene until that time is up. Is that correct?
That's their view. That's not our view of what the Sunshine Ordinance says. I mean, I think that the best practice is probably to allow the speaker to speak uninterrupted for that time. But the Sunshine Ordinance simply requires that the speaker get their allotted public comment time. And so I think that if there was, for example, a question that a commissioner posed and the public commenter responded to that question, I think there's an argument that question and response time would not count towards the 3 minutes. But if after that question and response time concluded and the public commenter was allowed to proceed with his or her time and got the full 3 minutes, our view is that wouldn't violate the ordinance.
So if the Sunshine Ordinance Task Force wants to refer the finding of a violation, ordinarily they would refer to the commission, obviously, or to the commission staff.
Right.
Obviously, that doesn't sound like a proper procedure. What is it? Should we refer to the city attorney or the ethics commission in Oakland or something?
I believe that's happened in the past, and we would consider which body to refer it to. It could be the Oakland Ethics Commission. We can I can sort of figure that out for you. But you're correct that this body would not hear a prospective Sunshine Ordinance violation against this very body. That would not be proper.
Commissioner Cobb.
My question, and maybe a comment is directed to page 3, the delinquent accounts. And the report states that after April, which means for our purposes, not until our May meeting.
No, for the April.
For the April meeting.
Right.
There's at least one item on here which simply is not understandable. That $2,000 item.
Mm-hmm.
That should be easy to collect. And I wish you'd inform whoever you're talking with accordingly. If they want my help, I'm available to give them the help.
Mm-hmm.
And these all carry what? 4-year statutes of limitation, or 2?
I think I'm not sure what BDR has. It might. Do you know, Josh? I'm not sure. I can look into that on what their collection statute of limitations is. But for our purposes, the Ethics Commission statute of limitations doesn't apply. So they have their own.
Well, 2 of these are going on 2 years.
Right.
And I don't understand them. Thank you, Mr. Chairman.
Any public comment on this item?
Thank you, Commissioners. Larry Bush for Friends of Ethics. We had 2 points that we wanted to raise. One was that we wanted to urge the Commission to adopt a standard for action on complaints. You've adopted a standard time for the city attorney and the district attorney to act, or that the Commission will act itself. And we urge that you do a similar kind of action on the part of the Commission so that you act on a complaint within 3 months or whatever period of time, but you definitely have a timeline for ethics. Because as you know, some complaints have lingered for 2 years before there's been any action at all. And the second thing is that we would recommend a priority for complaints to be addressed involving an official who is about to take office. Because in some cases, were there to be a finding of a violation, it could preclude the person from entering office if they were guilty of certain violations. As things stand now, there's very little information that's available until weeks after someone takes office. The election is in the first week of November. They take office the first week of January, but you don't see any reports about what finances they've been doing or not doing until the January 31st filing. So if a complaint has come in and it alleges activity that would be meritorious to examine, we would urge that that become a priority in advance of them taking office. Thank you.
Commissioners Ray Hartz, Director, San Francisco Open Government, and given the SOTF discussion earlier, I was the complainant in that case. This Ethics Commission is comprised of 5 members, 4 of whom are attorneys, with one being Dean Emeritus of Golden Gate Law School and another a former Superior Court judge. I have repeatedly identified the comments that members of the public, myself and others, make at these meetings as constitutionally protected political free speech. Not once has any member of this body or any other body where I have made that statement raised an objection to that thought. Thomas Aquinas teaches that willful ignorance of what one ought to know is a mortal sin. Instances where members of this body have either interfered with or attempted to censor public comment can be viewed as nothing other than willful. You know the law, you know what I'm saying is true, that the speech here is constitutionally protected political free speech and rises to the highest level of any form of free speech. The behavior of other members, sitting in silence as it happens, can be viewed as nothing less, in my opinion, than violations of their oaths of office. which include the statements to protect and defend the Constitution of the United States and that of the state of California. Interfering with or censoring public comment is bad enough, but is truly egregious when those actions are both knowing and willful. And there isn't a single member of this body present who can say that they don't know that what I'm saying is true. This is constitutionally protected political free speech and should not be infringed upon by law. And you can try to put a good face on it by saying, oh, well, that means the task force is saying we can't interrupt to ask a polite question. No. What they were saying was you can't interfere with someone's speech and then act as a censor. Say, oh, there are prohibited words. I sent inquiries to this body, and I said, okay, what are the profane words? Give me a list of the words that are prohibited. Or is it a minefield where every member of the public has to walk in and has to wonder whether or not somebody, not because they really are that worried about the profane word, but simply want to interfere with the speaker, will object? We saw the same thing happen to Michael Petrellis, where you made up rules that didn't exist. And it took a meeting with the sheriff, with Mr. Petrellis and I, to determine that the rules that you were telling us and other members of the public that existed didn't exist. You know we're free to speak. Let us.
Good evening, Commissioners, ethics staff members. My name is Louis Dillon, and I had filed a complaint with the Sunshine Ordinance regarding the closure of the historical stables in Golden Gate Park. And my complaint pretty much ratified the fact that corruption in City Hall through the mayor's office and the other city departments caused the 120-year-old business in Golden Gate Park to come to an end, with the promise of the government modernizing the stables and reopening them. And that was ultimately a ploy and a political grab to ratify the left members of City Hall and not have to deal with any of the equestrians in San Francisco. And so after 130 years, you're not seeing any horse-drawn carriages down at Fisherman's Wharf. You're not seeing children educated in riding horses in the city, taking care of horses in the city. And ironically, it used to be one of the greatest pluralities in San Francisco was the police department horses and the activities that came along with them. And so even though I did file a complaint with the Sunshine Ordinance and they agreed with my complaint, I then took it at the time to the Ethics Commission, which was again politically controlled and scuttled my complaint. So as a member of San Francisco's equestrian community, I make my living off of horses in the city, and I've seen nothing but political battles and unfairness that have led us to this tragic state where we've occupied a city that was previously built by equestrian-type, farming-type people. And so I'm going to be bringing the facts to your attention, showing you how Mayor Willie Brown overstepped his authority at the time and how the city departments, through pay-to-play politics, followed suit. Thank you for your time.
There being no further public comment, we'll move to the next item, which is item 9, discussion of the Executive Director's report an update highlighting various programmatic issues and operational activities of the Commission's staff since the previous monthly meeting that covers a range of topics such as the Commission's budget, policy developments, outreach activities, audit program, and future staff projects. Any of these subjects may potentially be part of the Director's presentation or discussed by the Commission. There are attachments to the March 22nd, 2017 Executive Director's Report and attachments.
Thanks, Commissioner
Pelham.
Keane. This month's report is very brief. As we note, Chair Keane and I have been doing outreach, a round of meetings with our most newly sworn-in members of the Board of Supervisors. We had one meeting. We have 3 now. I think that will be rescheduled to future dates coming up. But we will keep you posted about that. It's an opportunity to introduce the Commission again and introduce our work and identify how we might be able to work together on issues of shared interest. Also, in terms of an annual policy plan, the update for this month is shown as attachment 3. One of the notes that was referenced in some earlier comments, the whistleblower ordinance, the whistleblower protection ordinance. This has been something that's been under discussion with the Controller's Office, as I've reported in previous Executive Director reports, and the Department of Human Resources. We had an in-depth discussion with represented employee organizations on March 13th. That came at the request of Supervisor Breed, who had sponsored the legislation for us. The employee organizations have since requested to meet and confer about a proposal to require training for supervisors in the city to better understand and know how to appropriately handle a complaint that is brought to their attention about retaliation for having been brought a whistleblower issue forward. So that is something that the Department of Human Resources is going to be scheduling with all the relevant parties in the coming weeks. The Department of Labor Relations team from that department will be scheduling it. We don't have any further information at this point about what that date is, but we have every reason to believe it should be in the next several weeks. So we will be participating in that. As to staffing, that has been continuing to be a significant priority for us. There are a number of recruitments that are still underway. As you see on Table 1, the investigator legal analyst position. We've been in the interview phase, so there are 3 positions that we are hoping to fill in the next several weeks as that process continues and hopefully concludes. The investigative analyst, the 4th investigator, is in the exam phase and specifically in the review and rating of the exams, and that's the same for the policy analyst position. The open auditor position and a vacant education and compliance officer position, we have a request to fill submitted in one, and the request to fill is pending. So those are at the early stages of filling those positions. In terms of the annual policy report, just to go back to that for one brief moment, we'll bring an updated report next month. As we currently had scheduled or sequenced the items, we have planned to bring back at next month's meeting the enforcement regulations and review of related policies and regulations. That is something that will likely get pushed back 1 month as we dig into some of the other issues we talked about earlier. Also, under the ethics topics, the extending the e-filing mandate to all Form 700 filers, that does have a certain time frame that we're going to have to focus on this year to make sure that we bring forward a regulation to enact e-filing for everybody. But that also will probably then need to be moved back 1 month. So those are just quick flags for how we'll try and juggle some of the issues we've got on the radar. But I'm happy to answer any other questions that you might have.
Commissioner, yeah.
I have a question about the behested payments ordinance. I believe that was passed, and it goes into effect in January of 2018. Is that correct?
It becomes operative. The term that was used in the ordinance is that it becomes operative January 1st, and so that means that is the date that by which we're supposed to have a system that will be up and running to accept the Form 803 payments that will be used for officials. We need to develop an outreach plan and the forms to make that process happen. We have not done that yet.
In terms of becoming operative on January 1st, 2018, do we have enough runway to make that happen?
We will have to, and that will dictate what kind of a process we implement on January 1st.
Commissioner Kopp.
I want to talk about the staffing. And the people of San Francisco ought to know that this is a sorry record caused by our civil service process. As of July 1, 2016, this commission was authorized to have 4 investigators. There was one at the time. That one later departed. Now there are 4. It is now nearly April 1st. That means 10 months. I'm not going to get into a philosophical argument about public sector and private sector, but there's a sad lesson here for the people of the city and county of San Francisco. The executive director's report just referred to the number of complaints filed with the commission. The commission is provided every month with a document which tells the commissioners the state of various complaints and allegations. And it's sad to me, and it's sad to our entire commission, I think, and to our staff, that we have, even now, after invoking a 90-day rule with the district attorney and city attorney about holding on to allegations when they ask us to suspend any work, that we are still, in sports lexicon, coming from behind, way behind. And the people of San Francisco should know that this is an upright, hardworking staff which is beset with the handicap of not having 4 investigators 10 months after July 1, 2016. It is genuinely intolerable, and it should be rectified. So I will give public notice to those who are concerned that I intend as one person to collaborate with my fellow commissioners, our executive director, and all others in eliminating this sorry situation for the future. Thank you, Mr. Chairman.
Commissioners, I'd like to echo what Commissioner Kopp has said. I think he's made a very important point, and it's something that we should put our emphasis on. Is there any public comment on this item?
Thank you for your indulgence, Commissioners. Larry Bush for Friends of Ethics. We wanted to add a few things to the policy list that you have. We'd like to request that you add to the policy agenda a discussion of the Form 804, which shows free admissions that are given out by city departments. And how are those given out? What is the criteria for who receives them? Is that criteria somewhat bogus? And what is it costing the taxpayers our quick review of the past year's worth of free admissions is that the city has given up over $1 million in income that it could have received. And the reasons for people having free admissions include things like going to a sports event in order to see what the facility looks like. And it will be the executive director of the department, as though they didn't know what their own facility looked like until they could go to an event. We'd also like to suggest that you put in timelines for disclosure of contributions in the 10-day period after the second pre-election report, and so that we can see that what money is actually flowing in at that period of time. There's been discussions before the Commission about this before. It's within your legal authority to do that. As you know, we have a contribution cap of $500, but in the 10-day period before elections, only contributions of $1,000 are reported. Well, obviously, if we don't have $1,000, but only $500, nobody's going to report anything. So we've been providing information on exactly how much money that is, because our experience is that people give at the end of an election when they don't want their identity to be known, and often when the recipient doesn't want the identity to be known. Third issue is a document retention policy, which I know that you have on your list of things to do, but we would like to see that the document retention policy address such things as cell phone usage and retaining documents that would have come from that. So we're asking that all that be included in your future policy agenda, because I know that you don't have enough to do. Thank you.
There being no further, I'm sorry, Mr. Hartz.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I'd like to talk about the first item on here, the pending legislation regarding the Whistleblower Protection Ordinance strengthening amendments. On the matter of the whistleblower program, I would refer the public and the members of this commission to the comments made by Dr. Derek Kerr included in the ethics minutes of February 27, 2017 under agenda item number 8. And to make it very easy on everybody, those are the minutes that you approved tonight. And Dr. Kerr included a 150-word summary, and he talks about some very, very important issues relating to the whistleblower program. As a recipient of a very large settlement, somewhere in the range of $750,000 from the city of San Francisco for multiple violations of the program, he is certainly well positioned to speak to the issue. When Dr. Kerr states, quote, "The burden of proof is stacked against whistleblowers," end quote, he is exactly right. In considering his argument, I would like you also to consider the following. Begin quote, "You may consider the ability of each party to produce evidence. If a party produced weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence," end quote. And I think the attorneys in the room will recognize that from being the civil jury instructions that are given to juries saying that if you have one party who could have given you better evidence and they didn't, what evidence they did give you, you can look at sideways. And basically what it really comes down to is the city is always in the position of providing stronger evidence regarding whistleblowers and the retaliation that is in many cases sent their way. But it is always in their interest to withhold such evidence, even if doing so is unlawful. One of the things I've gotten used to, in fact, it is probably the most common comment I hear at every board and commission meeting, is comments about the city family. And it basically is, they're our family and we're not going to do anything if they do something wrong. In fact, we're going to turn our somersaults, if we have to hide the documents that show they did something wrong and to prevent them from ever coming before the bar of justice. I mentioned to you the Library Commission and the Friends of the San Francisco Public Library. I've been going after that for 8 solid years, and I will go after it for another 8 solid years until I root it out, because it has become such a pernicious and invasive and wrong matter that it needs to be brought to the public's attention. Listen to Dr. Kerr. Whistleblowers need protection.
Thank you. Yes, sir.
Thank you, Commissioners and ethics staff, City Attorney's Office. I'd just like to resonate with what Quentin Kopp said. There seems to be a definite disconnect between the people of the city and the people running the city, or how the city used to be run. I would term it as a dictatorship rather than a democracy, when it's not about the people's votes or the people's will. It's about a agenda that has specific goals, and it appears that anything goes and nothing matters in getting those goals or objectives achieved. My relevance here is that, yes, we do need 3 minutes of time to just get our point of views across to somebody, because there really is no other avenue in the city to do that. Even if you go to the Tuesday Board of Supervisors meetings, they're so well orchestrated as to pretty much drown out relevant public comment. It's all about these big issues, City College or police brutality or some other thing, but a lot of underlying issues have just never gone anywhere. And it's a small city, and that equates to apathy when there's no light at the end of the tunnel and the underdog doesn't have a shot. It's special interest, it's pay-to-play politics, it's a dictatorship that just doesn't care about what's really happening in the city, and constantly going to these meetings, you just get burned out because nothing happens. I feel like the city attorney's office is like a foreign entity that's taken over the city, and everything global and everything foreign is important. Everything local, everything traditional just doesn't matter. Thank you for your time. Thank you for appropriately running these meetings and giving us time to speak. And ultimately, you're the people that are going to make the decisions, and we are going to respect those decisions. Thank you.
Thank you.
One item that Charlie, for the record again, one item I don't see on the calendar is a discussion of your budget mechanisms. And there's something that should be imparted to this commission regarding what I call the best practices model, which is the New York City model, which allows the commission to file its budget with the mayor, but the mayor can only comment on those requests, and he must, in fact, reserve the amount requested by the commission and send it to the board in its total amount. So it's incorporated in the mayor's budget in toto, submitting it to the board for the purpose of slicing and dicing the policy issues or the funding mechanisms or the degree of funding in open session. So it's both in the board committee that handles the budget, but also at the full board discussion of the budget, so that any cuts or even additions would be considered by the board in open session at all levels, and it would be the votes would be taken in public session. That's the New York City model. The New York City model also has the granting of independent counsel authority by their corporation counsel in the city of New York. In this case, that would be done by the city attorney if it was constitutional, which I don't know if it is or not. But those are some of the things that the New York City best practices model has that we don't. And I thought it would be interesting to discuss that model and then take up possible other mechanisms for funding. For instance, there's a project going up at Oak at Franklin, where the zoning envelope is 45 feet, but apparently it's been agreed by the important players in the decision process to raise it to 320 feet in height. And I'm sure that's already been approved. But my point is that with all of the development occurring, I think we should look at a conditional use enforcement fee mechanism so that ethics gets a portion of designated funds collected from those applying for conditional use to do its enforcement and investigation and hire investigators to do that type of enforcement. So we'll talk more about that later, but there's that type of idea that we might be able to take up as an agenda item.
Hearing no further public comment, we'll go to agenda item 10, discussion and possible action regarding status of complaints received or initiated by the Ethics Commission, which will be, I hear a motion to that effect, a closed session on those issues. Do I hear a motion for closed session?
Mr. Chairman, ordinarily I would make one. But I don't know what a closed session will produce.
Okay.
I'm going back to my prior remarks, and I thank you for your association with them. Look, we've got a one-woman investigator for all of these, Jessica Blum. And it just grieves me, again, as I said, to see this document, which by law is confidential to the members of the commission, but I don't see anything that I'm going to learn which is new. Maybe that'll change. I'm being realistic in 60 days.
I would just have one question of Ms. Bloom. For 2 months, we've seen an indication that there were to be some show cause hearings, and they keep getting continued. And I take it that this is simply the fact that you just haven't had time to put the cases together for that purpose, right?
Yes, Commissioner Rennie, if I may just jump in, I think that is not an issue for Jessica. That has been my inability to sit down with her and resolve some matters to move forward. So you are correct. But
And with that, I concur with Commissioner Kopp that I don't see any need to have a closed session or any session on the subject matter of item 10 at this meeting.
I have only one other or further comment,
Commissioner Kopp, yes.
And that is to be assured that 90-day rule with the district attorney
Yes.
is being followed, right?
Yes.
Thank you.
I think we do need public comment since it is an agenda item. Do we have any public comment on this? Okay. Hearing none, we'll go on to agenda item 11, discussion and possible action on items for future meetings. Commissioner Kopp.
I have a number of them. and they reflect the time and the effort, primarily from Friends of Ethics, which is certainly a redoubtable entity composed of genuine, civically minded people. I should like to supplement the list from the so-called Proposition J subject matter with the following. And the following are going to be about 7, 8, or 9, Madam Executive Director. I think almost all of them have been commented on, and almost all of these must take the form of legislative action by the Board of Supervisors and or charter submission by this commission, depending upon the outcome in the Board of Supervisors. First, there was reference by a citizen who spoke earlier, Mark Solomon, to a potential conflict of interest by a member of the Planning Commission who was or is now SPUR. What is it? I've forgotten the acronym stands for. It's been so long. Planning and Urban Renewal. Director of everything which occurs in San Francisco. And as has been pointed out, SPUR is a major conduit for money from developers, which pays the salary of that planning commissioner. That seems to me to be ripe for action legislatively if it isn't already a prohibited conflict of interest. Secondly, there's been reference also to former law and practice that identified in the voter handbook candidates who were the recipients of public campaign funds. And secondly, to a requirement if a candidate received or applied for and received public campaign funds to engage in more than one debate. I'm going to be a little bit arbitrary in suggesting and asking for consideration of 3 debates participation. And I think also consideration should be given to identifying in the voter handbook candidates who did not receive public funds, did not apply for public funds, so there is complete disclosure to prospective voters. Thirdly, we've already discussed the audit policy considerations, and in that discussion there was reference to the fact, I think by a citizen who testified, it may have been Mr. Bush, that slate mailer regulation is the domain of the Department of Elections. I agree with the comment I heard that it should be the domain of the Ethics Commission. And in that same connection, there should also be some priority given in the audit policy to prior violators of any of the laws which form the subject matter of the Ethics Commission's responsibilities, as well as those already mentioned who, by testimony from Mr. Bush, as well as those who fail to identify the occupation or address in their campaign reporting statement. You'll recall his testimony about those being the most likely violators of anti-laundering laws. Fourthly, I think we should impose a deadline on ourselves for action. Mr. Bush mentioned 3 months. I'm going to suggest 6 months after a allegation or claim of violation, and that, I would think, can be done by regulation, by our own rules. But anyway, the attorneys can opine on that legal point, but I think we should impose a regulation too. It's going to be a better world, Ms. Pelham. You're going to have 4 crackerjack investigators and 5 characteristically attentive commissioners. So it's feasible. It's feasible. Let's see. I think also, and this will take maybe a charter amendment. If an elected candidate, successful candidate, is under investigation with an investigation based upon allegations that have not been completed, that person should not be allowed to be installed in the public office to which the person was elected. I don't know if that's precedential, but I'm sure research will show whether that occurs. L.A., New York, Oakland, wherever else our responsibilities are duplicated. There was also mention in public commentary tonight of the practice of city officials receiving tickets to events, entertainment events that the public must pay money to attend. And I think I recall testimony. That's right. Friends of Ethics estimates that that amounts to about $1 million a year in what can be characterized as lost revenue to the city, to the taxpayers of this city, because those are tickets which aren't sold and they're given away to public officials. I also think we need, this is a rule, I guess it's a rule, no, maybe it is an order. Document retention, we've discussed that a couple of times, and we had a couple of cases that involved it. But we need to finalize a document retention policy, and the private cell telephones and all of those intricacies. I further want us to act, and I'd like all of these calendared in some responsible but still sane fashion, maybe not all in April, maybe some in April, maybe some in May. I'll leave it to you, Mr. Chairman, to make that customary decision, that this business of pre-election, the 10-day period before election of those local $500 maximum contributions, there are $100 to $500. $100 you got to report it. 99 you don't. But the $100 to $500, that should be covered on the same basis that the law now covers and requires $1,000 or more contributions the last 10 days to be reported every day. Couple more, and I will be exhausted. There was mention earlier today also, or maybe it was in informal discussion. I want to be sure it's legally within the purview under the charter of the Ethics Commission, but if it isn't the Ethics Commission, it certainly is the Board of Supervisors, and the Ethics Commission can make recommendations that there be inserted in San Francisco law, charter, ordinance, that an appointed officer or employee of the city and county who becomes a candidate for election by the people of the city and county of San Francisco to any such public office shall automatically forfeit their position as an employee or officer of the city and county of San Francisco. And there was offhand reference, I can't remember which citizen speaker tonight, but the thrust was embodied in a couple of ordinances that have been drafted in the Board of Supervisors. And it gets a little bit technical, but it deals with nonprofit so-called housing and community development entities, which under a series of transactions involving loans and then sale of the property after it's developed for low-income housing and I guess middle-income housing and regular market rate housing, have the ability to participate in political campaigns with excess money and can make donations to candidates and can make donations to urging yes vote or no vote on ballot measures, and apparently have done so. And I will provide staff with copies of these two proposed laws. There's a term which is employed that is called cash out proceeds. Have you ever heard of cash out proceeds? Well, it's defined in the I'll give you this little tidbit just to end it. It means in connection with any sale, transfer, or refinancing of an affordable housing development, any and all funds received by an owner of an affordable housing development that are not needed or utilized to retire existing debt or construct, improve or preserve the affordable housing development. Something like a little profit out of a series of transactions, and you use that profit to campaign so far against ballot measures or for ballot measures. Even though public financing isn't approved or authorized for ballot measures. But it's taxpayer money. Okay, I shall desist.
Well, it's a good set of work and tasks for us for the future, Commissioner Kopp. I want to compliment you on that list.
Thank you.
Any comments by commissioners? Or we'll take public comment then.
Commissioners, Ray Hartz, Director, San Francisco Open Government. And I'd like you to take a look at this list. Sorry about the small type, but once you get past 30, it's kind of hard to get them all on one sheet. I now have 33 orders of determination from the Sunshine Ordinance Task Force relating to one of two issues, either access to public records and the denial thereof, or interference with public comment at public meetings. And whether you like it or not, the Sunshine Ordinance is city law. And whether you like it or not, you are responsible for enforcement of this and never have done a single thing but one time. Literally for years, this law has been ignored by this body, just like you are ignoring me right now. The bottom line is, I've heard a lot of comments about, oh, the task force, what's up with them, and and really the comments really sound a little bit ignorant. In that if you don't know what the task force does, when you have rules and regulations in your own from your own staff that tell you how to deal with the complaints and how to process the complaints and how to do it, it's just kind of a willful blindness. We don't like this law, and we don't like people like Mr. Hart's coming here with 33 of these things and saying, why don't you do anything about it, because it makes us look bad. And it does. One attempt was made, and Commissioner Kopp at a previous meeting kind of referred to it, and he says, well, we can't make the mayor fire somebody, can we? No, you can't. But haven't you got the moral responsibility, if you feel that someone has done something wrong, to recommend to the mayor that he take some action? Or is it simply, well, we don't want to embarrass the mayor because the person we're recommending he dismiss is a mayoral appointee? So we'll send it over to the mayor, and if the mayor chooses not to answer, we'll just accept that. You know, it's all well and good to have all these rules and all these regulations and make all these processes and procedures, but if you never are able to enforce any of them, and very frankly, this is a question I've asked of this body over and over in the last 8 years. Can anybody here give me an example of anything this Ethics Commission has done that has really made this city government more open and more honest? And I am always met with a reply that is nothing but utter silence. You shuffle papers, you change the rules, and it's like rearranging deck chairs on the Titanic.
Commissioners, ethics, staff members, city attorney. Yeah, I'm just overwhelmed at the fundamental changes that I feel are going to take place here with, it seems like, genuinely interested people on the commission that are, not bought and paid for. And that is very, very good to hear. Some of the statements coming from the commissioners sound like they're genuinely trying to expose the government, which is what the Sunshine Ordinance was all about. It's so easy when you have a city government structured like this to have the mayor's opinion or decision just taken for granted and done. And that's not a government by the city for the people. So, yes, I'm very optimistic about presenting you the facts of how this doesn't work by showing you previous attempts in my complaints and my orders of determination that were in my favor, but yet I was not able to come to some sort of resolution with the city. The stables were closed in September of 2001. which I'm sure you all were aware of was a very tumultuous and changing time for the nation, as that's when 9/11 happened. But the stable inhabitants were evicted exactly at that same time. And the mayor that authorized that resolution then came out after the 9/11 attacks and said he was the only person to have advance warning of the attack, the only person in civil service in the United States that knew about the attacks, and he was told not to travel. And the same person authorized a resolution evicting every equestrian in Golden Gate Park stables, promising them a rehabilitated, better functioning place. And you can see what we got, 0.
Okay, hearing no further public comment, at this point, I will entertain a motion to adjourn.
I have a point of personal privilege.
Yes,
I
certainly,
want to
Professor.
exercise.
Certainly.
Sitting in this very room is the best paralegal in the city and county of San Francisco. I'm going to give him his 30 seconds of fame. Bradley J. Kopp, stand up. Thank you, Mr. Chair.
All in the genes, Commissioner Kopp. Do we have a motion to adjourn?
So moved.
moved.
We are adjourned.